opposition parties, led by the Congress, on Friday met Vice President and Rajya Sabha Chairman Venkaiah Naidu and handed over a notice for impeachment of Chief Justice of India Deepak Misra. The CPI, CPI-M, NCP, SP, BSP and the IUML are the other parties that have agreed to the motion.
So we have moved a motion for impeachment for the removal of Chief Justice of India under 5 listed grounds of misbehavior. We have sought his removal under Article 217, read with Article 124, bracket 4 of the Constitution of India.
The Congress, after meeting Vice President and Rajya Sabha Chairman Venkaiah Naidu, confirmed that 71 MPs had signed the impeachment motion against Chief Justice of India Deepak Misra.
We wish this day had never come. In the framework of our constitutional fabric, the judiciary holds a very special place. Its independence is a constitutional imperative without which democracy will flounder. It must guard and protect itself from external interference and must be above suspicion. This is why judges must uphold the highest standards of integrity. They must also be tested by the same standards. In the scheme of things, within the judicial setup, the office of the Chief Justice is an exalted position. He is one among equals on the judicial side, but has vast powers on the administrative side. Since Chief Justice Deepak Misra was appointed to the high office, there have been situations when questions have been raised about the manner in which he has dealt with certain cases and taken certain administrative decisions. There have been internal rumblings resulting in open discord amongst judges in the Supreme Court. This manifested itself when 4 senior-most judges held a press conference on January 12, 2018, where they publicly expressed their disquiet about the manner in which the Chief Justice was exercising his powers.
So we have submitted a motion signed by 71 members of the Parliament, but we have also given him in writing that there are 7 signatures of honorable members who are meanwhile retired.
They said that time and again, as senior members of the court holding a responsibility to this country, they tried to collectively persuade the Chief Justice that certain things are not in order and that he must take remedial measures. They lamented that their efforts had failed, and all 4 of them were convinced that unless the institution is preserved, democracy will not survive in this country. Recent communications of 2 senior judges to the Chief Justice reveal that the Chief Justice has not asserted the independence of the judiciary in the face of interference by the executive. The first charge relates to the conspiracy to pay illegal gratifications by persons in relation to the Prasad Education Trust case and the manner in which the case was dealt with by the Chief Justice. The second charge relates to the Chief Justice having dealt on the administrative as well as the judicial side with a writ petition which sought an investigation into the matter of Prasad Education Trust, in which he too was likely to fall within the scope of investigation, alleging that the note of 6th November brought to the attention of Justice Chalmeshwar on 9th November, as the matter was taken up, was antedated. The charge of antedating is by all accounts very serious. The fourth charge relates to the Chief Justice having acquired land when he was an advocate by giving an affidavit which was found to be false. Further, despite the orders of the ADM cancelling the allotment in 1985, the Chief Justice surrendered the land only in 2012 after he was elevated to the Supreme Court. The fifth charge relates to the abuse of exercise of power by the Chief Justice in choosing to send sensitive matters to particular benches by misusing his authority as master of the roster with the likely intent to influence the outcome.